morning, everyone. Thank you for joining us today. My name is Yaser Faily. I'm a licensed realtor in California. We are here today to discuss a very important subject. So stay tuned to the end of our webinar. If you have any question during our webinar, please write your comment down below. We will answer your questions soon we finish our webinar. As we know, all of us would like to pass on a little something to our children or our loved one. We save and save to make a life a little easier to the people we are care about. The last thing anyone wants to give a large portion of their hard-earned money to the government in the form of the probate fees. We don't want to see our loved one, especially our spouses and children, to wait months, even a year, to receive a penny. Avoiding the delays and the cost of probate is much easier than you think today. Here's some facts that we would like to share with you today, talking about real estate and living trust and how to avoid the probate home sale court process. Without further ado, let me introduce our presenter today, Attorney Armine Bazikyan from Bazikyan Law Group. She's a certified attorney by the State Bar of California, a specialization in the specialist area, estate planning and trust and probate law. Good morning, Ms. Armine. How are you doing today?
I'm doing really well. Thank you for having me.
Thank you so much. Ms. Armine, can you tell us more about your background and also about your law firm?
Sure. I've been practicing within the world of trusts and estates for close to 11 years now, exclusively within this area. I help clients plan their estate, meaning we help them write up all of the documents related to their will or their trust for death and incapacity purposes. And then we also help clients administer those trusts or administer a probate estate if they haven't done any planning. So we also help when the person has actually passed away and we need to go to court or we need to administer the trust. We're a very small boutique law firm located in Glendale, California. But thankfully, we're able to service most areas of California since I am licensed in California. And that's pretty much it. We're a very family-oriented law firm, so we treat our clients like family, and they walk in as strangers and walk out as friends, essentially. And we like to keep the relationship alive during the course of their life so that we know all the changes that happen in their life and we can better help them.
Yeah, great. So a lot of people asking the question, what's the definition of a probate? What's the legal definition of a probate? Why we are using the probate for?
So probate is the name that the California law gives to a process. So probate essentially means that it's a court process that people's assets have to go through before they're given to family members. It's a legal process. A case needs to be filed when a person passes away and they own assets in their name that are valued over $166,000. Currently, the number is about 166 and some change. Every year, that number slightly changes depending on the law changes. So currently, it's 166,000. So if an individual owns real estate, for example, it will go through a probate process when they pass away. So that's the legal process that we call probate. There are some things that don't necessarily go through probate. For example, if there's an account that has the ability to put a beneficiary on there, what we call beneficiary designated accounts, those accounts do not go to probate. Or for example, if there's a house that's owned in joint tenancy, that house does not go through probate because there's another joint tenant that's still alive. It goes through a different process. But for the most part, generally speaking, valued at over $166,000 in assets, the estate goes through this court process.
Oh, great. So for the probate process, how does that work? I mean, how do we start to do the legal procedures?
Normally someone has already passed away. We always, the way my firm works is we don't like to just jump into probate because family like to take, we like to give people space to mourn the loss of their loved one first. There is no emergency speed at which you need to file for probate. There's some people who file for probate 5 years after someone has died. There's people who do it literally the next day. So it really just depends on your speed. Legally, if the person had a will, it needs to be filed within a certain number of days. So there is a timeline. But really, you're not going to get anything more than like a slap on the wrist if you don't do it within that timeline. However, depending on the scenario, right? So normally someone passes away, they come see an attorney, and the attorney would prepare all the legal documents. We would file it in court. For your purposes, it takes about, currently in California, for LA County courts, it takes about 3 months to get what we call letters of administration. The letters of administration is what gives the family member, whoever is doing the administration, whoever is in charge of the estate, whoever's petitioning the court, power to do whatever they need to do with the property. And most of the time, that includes selling the house. And there's different levels of powers that the individual can have. But until they get those letters, what we call letters, it's actually just a one-page document. I don't really know the history of why they call it letters, but it's basically a stamped document by the court that says, okay, Bob, you're in charge of your wife's estate. You could do whatever you need to do with this property. And then Bob could turn around and sign escrow paperwork or get a loan or do whatever they need to do with the property legally. Legally, they become the person that's in charge. It's depending on what type of assets there are or what type of authority the person has. The probate can kind of go left or right or in the middle. There's different roads it could go down. But for the most part, there's work that happens in the middle that has to do with giving creditors notice so that if the person owed money to anyone, they can come in and take it at that point. Once we get past that stage and valuing the property, making sure everything's paid and everything's settled, the end stage is called distribution, where we actually give the assets to the rightful people according to the law or according to what the person wrote in their will.
Oh, great, great. So this question actually related to real estate. I know you mentioned about selling the house. So the process, if I can sell, like for example, can I sell my house during the California probate? Like there's a process going on, and I don't have an attorney at this time. So this is the most challenge people actually getting when, especially if somebody passed away, and they actually during the process of the sale of the house, and that's you have an issue, legal issue start. So what's the best advice to to start how we handle the situation and for this kind of situation?
Yeah, you're absolutely right. Most people discover that they need to go to probate when they go to sell the house. So let's say mom and dad died a few years ago. They live in the house, right? The child lives in the house. Everything's fine because it's either paid off or they continue paying the mortgage payments. And then one day they wake up and they say, I think I'm going to sell this house. They list the property with an agent. Hopefully at that point, the agent does a title check and says, wait a minute, you're not the owner. This other person is the owner. Usually at that stage is when the person discovers that there needs to be a legal process done, because if they're working with an experienced agent like yourself, they'll educate them and say, hey, you need to go through a legal process. Let's get that rolling now. Sometimes they don't, and they go through the whole process of signing the agreement and going into escrow, and then title tells them, when the title check comes back, they say, you're not the rightful owner. Your mother was. We need a court order. So it basically stalls the sale. And most of the time they lose that buyer, right? Because the buyer's not willing to wait 3 months or 4 months or however long it's going to take. So I would say if you know you're planning on selling, clear title earlier on so that you can go into escrow legally knowing that you're the rightful person signing the contract. Even that offer and acceptance, when someone signs it and they're not the legal owner, it's not a binding contract. So the buyer, once they discover you're not legally the owner, there's no valid contract. They could just bounce. So really to protect your rights, if you want, a good deal on the table to be valid, you should have the proper rights given to you by the court to be able to sell it.
Oh, great, great. So this is probably most common mistake people they do during the probate.
I think the most common mistake that I see is a family, they get informed that they're not the rightful owner, they need to go to probate, and then they go find a service company that promises to clear title for them. And these are kind of the companies that are paralegal processors, where they just do the paperwork for you and they charge you a set amount of money to do the probate. They're not legally attorneys, right? They're not licensed by the state of California. So usually what happens when someone passes away and their death certificate becomes public record, all of these different companies will buy all the death certificate information, and they'll know whether that person, they'll cross-reference it with real estate records and know whether that person owned real estate. And then they will bombard the family with letters in the mail. Hey, come, let's do your probate. Let's do your probate. So I think the number one mistake I see is people not hiring an attorney and hiring a company like that to prepare all their probate paperwork. I have one right now that's exactly that scenario where they paid $3,000 to some company to do the paperwork. They signed all the agreements, and after the first couple of meetings, they've just disappeared. They can't find them. So they didn't know whether their hearing was going to be handled properly or not. So they kept reaching out to the person they were in contact with, and it was radio silence. So they decided to drop that company and hire an attorney. So they lost out on all that money they gave. They're in the process of trying to find them actually and get it back, and so we can sue them to get it back, because what they're actually doing is illegally practicing law. So I think the number one mistake I see is people hiring non-attorneys to prepare their probate paperwork. If it was an easy process, it wouldn't require an attorney. That's what I always say. The second mistake I see is people trying to do it on their own. So they'll start the process on their own, and then at the hearing, the judge will demand certain things of them. They'll say, you know, you haven't cleared notice, you haven't cleared publication, or whatever it is. And the judge is throwing out legal jargon and legal terms. And then they'll say, well, how do I do that, Your Honor? The judge cannot legally give you help. He's in a position of a neutral. So even though his heart is breaking on the inside, he wants to tell you, like, it's easy, just call a newspaper and publish the report. He can't legally say that on the record. So he constantly says, you know, you need to go back and hire counsel, and you need to clear these points. So then you go back to a second hearing, same problem. You haven't done what the judge says, or you did it but didn't do it correctly. So it ends up stalling the probate. You end up costing yourself much more time, which at the end is more money if you're planning on selling and whatnot. So the do-it-yourselfers, I think, cost themselves the most amount of money, and the people who want to cut corners or save a little bit of money by going to these companies to have them do it. That's also a second mistake that I see all the time. Other than that, everything, I think if you have an attorney on board, there shouldn't be any mistakes that you made, because the attorney guides you through the process of what to do. I think don't do anything until you have that attorney. Don't kick out tenants or, you know, do anything like that, because there's certain laws that protect certain tenants, especially if they're beneficiaries as well. So it's always good to just have the guidance of an attorney before you do anything legal.
Well, the best, question actually, how to avoid that probate? All this problem, how to avoid it? Is there any option there's an answer for this? Do we have a solution for this?
Absolutely. We don't like probate. I earn much more money going to probate, but we don't advise clients to go through that process. My primary occupation is to avoid probate for clients. So a client will hire me to prepare documents that avoid that process. So in order to avoid, so let's take a step back for a minute. The way that people end up in probate is by not doing anything at all. They didn't do any paperwork whatsoever during their life, so they end up in probate. Or they did paperwork, but the only thing they did was a will. So if you prepare just a simple will, it goes through probate. And I think this is one of the mistakes in the public, or one of the myths in the public. They think that if they do a will, they avoid probate, they've done all of their homework, they don't need to worry. But that's not the case. The difference is that if you do a will and you end up in probate, instead of the judge reading what the law says and giving it to the people that the law says the assets should be given to, they actually read what you wrote, and you wrote, oh, give it to my neighbor. And they say, okay, he wanted it to go to his neighbor. Let's give it to the neighbor instead. If you don't have the will, the judge will look at the law and say, okay, next closest relative is your third cousin once removed. Let's give it to that guy. So that's the difference between having a will and not having a will. They both end up in court. The judge is going to supervise both procedures, same process, identical almost. The way that you end up outside of the courtroom and doing it privately is by creating what we call a trust, a revocable trust. I like to describe it as a basket. We create a basket. We take all of those valuables that you're currently holding on to in your pockets, right, on your body. We take all of those valuables and we put it into this basket. When we put it into the basket, it's no longer stuck to your body, so that when you die, it doesn't go to probate. So the way I like to describe it is everything that's on you when you die ends up in probate. So if I take something out of your pocket and put it in this basket, it doesn't go to probate anymore because now it's owned by the trust, the basket that we created before. And then within that basket, you let us know who you want to be the person that holds on to it after you're gone, who you would like to get the assets from the inside. So you might say, okay, great, I have this basket, I've put my house in it, I've put my bank account and my life insurance. When I'm gone, give this to my brother. He's gonna be the one that holds on to this basket. He's gonna reach inside and give the house to my son, give the bank account to my daughter, give the life insurance to this other person, whatever it is that you want. He's gonna be the one in charge and he's gonna control the basket and do exactly what I wrote. So that's what we call a revocable trust. And the revocable trust right now in California is one of the ways of avoiding probate.
Oh, great, good. And how long that process will take for this doing the trust?
The trust, it depends, I think, on the law office. So for
Okay.
our office, for example, after our first initial meeting with the client, it takes me about 2 weeks to write everything. It takes me a little bit longer than probably, most attorneys because I don't have cookie cutter forms that I just plug in information to. So it takes our office about 2 weeks to write up all the documents and send it to the client for review. Most clients will take about a couple of weeks to review it and make sure everything is what they want. They haven't changed their mind, or we might have meetings back and forth about different changes. And then once they get comfortable with what they want to sign, they'll come in and we'll sign and notarize everything.
Oh,
so
great.
for most people, average about a month, but then there's some people that take a year.
Wow, okay. There's any update with the law regarding the trust?
Nothing significant related to estate planning. There have been, at this point, no changes with respect to estate tax exemption amounts. We're all pretty sure that there are going to be some significant changes to the exemption amount, to the death tax, as we call it, with all of the money that's being given out by the federal government. I'm pretty sure they're going to revisit the estate tax as a way of generating income, as a way of generating taxes. But as far as estate planning is concerned, everything is pretty much still the same. There's been some different ways of how we're handling people's healthcare directives and powers of attorney for health. We're putting in specific clauses related to COVID because people have different wishes related to COVID. They don't want the plug pulled if they're on COVID, if they're in the hospital because of COVID. So there might be some specific wishes that we have related to COVID sickness as opposed to everything else, but otherwise it's pretty much the same.
Yeah, great. Ms. Armine, thank you so much for pretty much we covered almost, there's a more question I have, but I don't want to ask too many questions, but let's the audience, maybe if they have any question, you guys, if you have any question, you just write down, your comment down below, and me, Ms. Armine will get back to you. I mean, she's going to leave her contact information, and if you have any question, you can get back to me, or you can call Ms. Armine, her office.
Thank you for having me. And we offer free consultations, so please take advantage of that. Have a good one. Bye-bye.
Thank you so much. Bye-bye.